إن في الجنة نهرا من لبن.
Bismillah. The Shaykh said then that in looking at this khilaf, he wants to tell a story while looking at the hadith. In other words, in the story you'll see the hadith emerging and how this came out. He said, as we know, in the past, it was the nature of the seekers of knowledge, the talabat al-ilm, that they would go and they would seek knowledge by seeking out the ulama in different lands and places and asking them questions about the difficult matters and what they were learning. And he said in the 2nd century of Hijrah, many of the ulama would go to Hajj, and the students of knowledge would go to Hajj, and they would be able to see these different ulama at the same place. They might not be in the same places where they came from, but they'd be in the same place at Hajj. And he said during that time, the three of the greatest ulama of al-Iraq were Abu Hanifa radiallahu anhu, Ibn Shabruma, and also Ibn Abi Layla. These were three fuqaha that were well known, and everybody considered them to be references of the sacred law. And some of the students who were having difficulties in understanding the concept of buying with conditions. They wanted to know, is buying with a condition, with a stipulation, is it permissible or is it not permissible? So they went to Abu Hanifa radiallahu anhu and they said, what do you think about some business transaction of buying and selling in which there's a stipulation in that? Abu Hanifa radiallahu anhu said, the actual transaction is invalid and the condition is invalid. So that was one opinion. And then they went to Ibn Shabrumah and they said to him, what do you say about buying with a condition? And he said that the buying was valid and the condition was valid. So he said the opposite of Abu Hanifa. And then they went to Ibn Abi Layla and they said, what do you say about the buying and selling here with a condition? And Ibn Abi Layla said, the actual transaction is valid, but the condition's invalid. So at this point, obviously, they don't know what's going on. They got three completely different answers from three different great ulama. These are all knowledgeable people. So they go back to each one. They say, you said this, and so said this. And Abu Hanifa radiallahu anhu said, I don't know other than I was told in this hadith, and he related the isnad of the hadith back to the Prophet ﷺ. So the Shaykh mentioned that these differences in fact result, and based upon these differences, there are many disagreements about human transactions. And he said, for instance, in our time, there is the idea of renting until you own something. This is obviously a type of condition that you're stipulating in the buying, that you're going to be renting this, but you rent to own, for instance. And so he said, and there are many other examples of this. For instance, he said, Imam Malik radiallahu anhu mentions in his marriage rulings, he says that a woman can stipulate in the marriage that she doesn't want a second wife and brought into the marriage, or a third, or a fourth. She can stipulate that she does not want polygyny. And it's not outlawing it because it's permissible, but it's a marriage with a stipulation. So there's a condition in the contract. Imam Malik accepts that. And he said this is obviously an important aspect of Sharia, especially for the women. The khilaf does have, the difference has social implications for people. And so that difference exists. You can start hearing all the... Suddenly this side got very busy. Why didn't they tell us that before? So he said also another one is the stipulation of staying in one place. The woman stipulating of staying in one place, for instance, near her parents, something like this. Imam Malik will recognize this, whereas the other imams won't. So these type of khilafat, these differences, are actually really important. And Imam Ibn Taymiyyah, rahimahullah, who was one of the great imams of the Hanabila, he agrees with Imam Malik in this, even though he's a Hanbali. He agrees that in fact these are valid conditions that should be accepted when they're stipulated. He said another condition is the condition of inflation. that there's actually people that, because of inflation, the instability of local currencies and of really all currencies that are based on fractional reserve banking, that when you have inflation, you want some guarantee. Because in some countries, wealth can suddenly drop a third because of the banks change the rates. And so a person, when he's buying and selling, wants to ensure that his money, the monetary value, is going to have some consistency, because that's the foundation, basically, when you're using gold and silver. And so he wants to stipulate in the contract, if inflation does occur up to a certain point, for instance, 10%, 15%, then I am going to increase the charge. Even though we've agreed on a price, within the next month, when the transaction occurs, we could have a collapse of the currency, and so he wants to stipulate in it to ensure that he doesn't lose all of his money, that it's because this type of situation. So these are all really important differences, especially in the modern world, because many of the transactions now involve lots of stipulations. You can see when you buy things, there's all these stipulations and things like that. So they really do have a very important relevance at arriving at this. And this is all based on whether or not the foundation of transactions, is it permissible? If there's no clear proof that it's impermissible, is it permissible for us to do transactions as we see beneficial to us, in the absence of any textual evidence that it's not permissible or not? And so from the original, what he's showing is from the original difference that he mentioned about these imams, of whether the root things are permissible or impermissible, then to the next level of it, which is about whether or not in transactions it's permissible, and then finally how all of these differences begin to emerge based on these essential differences. So these are important differences in the Sharia. So he said, let us return now to our qaida. The qaida is al-yaqeen la yazuru bil-shak. And he said that this is an important qaida in the sense that al-yaqeen, it relates basically to responsibility and when responsibility is removed from the person. So that's at the essence of this ruling. And he said that this is an extremely important qaida, especially when we look at those things such as legal rulings that occur in courts. When we look at what the qadi, who listens to people, he listens to the one claiming something happened and to another one claiming that it didn't happen. These type instances, and when they swear under oath, these type things, it's important in relation to the groups and to individuals and many other things. And then he mentioned that obviously that this qaida enters into both ibadat and mu'amalat. It enters into those things that are devotional between a servant and his Lord, and those things that are related to human transactions. Those things that relate to the behavioral transactions, financial, marriage, all these type of things between the creation. So he said you can see that this ruling then applies to tahara, it applies to fasting, to salah, it applies to prayer, to sawm, to fasting, to making hajj. There are rulings that are dependent upon this qaida in determining what exactly the ruling is. And he said it also enters into the mu'amalat. And he said, for instance, if a person leaves his house, and he said we're going to look at how this relates to ibadat. If a person leaves his house and he did wudu in his house, and then he goes out, and then later on the adhan goes, he decides he's going to go into the mosque and pray, and then he starts doubting, am I in wudu or not? Now he remembers when he left the house that he was in wudu. But now he has doubt. He doesn't have any certainty that he broke his wudu or even dhan, but he thinks, he doesn't know. It could be either or. In this instance, he applies this qaida, al-yaqeen la yazuru bil-shak. The yaqeen is not removed, the certainty is not removed by doubt. So the origin then is that he was in wudu, so he goes in and he prays. Now Imam Malik, he differs in this ruling. He says no. Now what the Shaykh said is it is important to understand that Imam Malik radiallahu anhu is not disagreeing with the ruling. He's not, he confirms the ruling. The ruling is sound according to Imam Malik, this principle, this axiom that we use. But Imam Malik differs between conditions and preventatives. In other words, Imam Malik says that shak لا يؤثر في الشرط. That the shak, the doubt, in fact, has an impact on a condition. Now, tahara is not desired for in and of itself. It's a condition for the validity of your prayer. So when you are going to your prayer, Imam Malik says, indeed, if you have doubt that whether or not you're in wudu, you're not in wudu. Because you need to enter into your prayer with the condition of wudu, and you need to have certainty. Even if you were certain before, the fact that you're doubting means that you can't enter in. So he differs. Now, if it's a preventative, he says, indeed, it doesn't affect it. A mani', right? And then people that have studied that basic section, it's in all the beginning sections of fiqh. Now then he says that also, if you look at Imam Malik, najasa is a mani', is something that it prevents you. It's not a condition. It's something that prevents you from praying. If I have something foul on my robe, it prevents me from praying. Now, Imam Malik radhiyallahu anhu says, if you doubt whether you have najasa that is on your robe or not, he says you just take it and you like put water in your mouth and you blow on it, and you're not washing it, or you take water and just sprinkle it on it, which is called nadah. It's not removing the najasa. So Imam Malik says you do that not to remove the najasa, you do it ta'abudiyah. In other words, it's not really understood, right? Although it removes that doubt that people have about it. So the point is that Imam Malik radhiyallahu anhu, even though he doesn't apply this qa'idah to tahara, he has a reason for why he's not applying it. It doesn't mean he disagrees with the other imams. He agrees with them, but he has a fine-tuning here in differentiating when you apply the ruling and when you don't. So the Shaykh said then, if we look at how this applies to our prayer, he said that if a person doubts whether he prayed 2 or 3 rakats, he builds on his certainty, meaning that he prayed 2 instead of 3. If he doubts whether he prayed 3 or 4, again, he builds on his certainty. So we're practicing this qa'idah. Al-yaqeen la yazuru bishak is being practiced here. Your certainty does not diminish by doubt. So you're doubting 2 or 3, you go with your certainty, which is 2. You doubt 3 or 4, you go with your certainty, which is 3. And then you build on that and finish a 4th one or finish the next 2, etc. And he said, but again, based on this qa'idah, Imam Malik differs. And now we're going to find also that Abu Hanifa radhiyallahu anhu differs as well. He said that Imam Malik radhiyallahu anhu differentiates between 2 types of people. One person is somebody who has a normal mental condition. In other words, they might doubt rarely or occasionally, but it's not a common occurrence. It's not something happening all the time. This person is mu'tad. He's just normal. And then another person is called mustankahu shak, is somebody who has constant doubt. That doubt is always afflicting them. He's also called muwaswis, which is somebody who has like obsessive compulsive doubt. It's happening every day. Now, Imam Malik says this person has a different ruling from a normal person. In this case, he actually builds on the doubt. He doesn't build on the certainty. So if he has 2 or 3, if this happens every day, once a day, that's it. Every time he doubts, what he'll do is, did I pray 2 or 3? Khalas. He puts it as 3, and then he does a sajda after. So this is just something that he's going to do all the time. Because he has a hukum that differs from a normal person. He's somebody who has doubts. He's a doubtful person. Now, Abu Hanifa radhiyallahu anhu says that he differs on this also, but he has an even finer tuning than Imam Malik. He says if he doubts about the first one, so now he's he prayed a 1 rakat and he's saying, did I pray 1 or 2? Khalas, he'll consider it 1. But if he does it in the 2nd rakat, did I pray 2 or 3? Then he goes into the hukum of muwaswis. So he does it. There's an even finer tuning there. So the Shaykh said that this is an example of using this qa'idah, but then again the fuqaha are differing, fine-tuning it the qaida still stands. And that's what's important to note. The qaida still stands, but the ulama do tune it to different circumstances. So the Shaykh said that this qaida, this axiom, also benefits the qadis, the legal judges who are dealing with rulings, when they're trying to see who is the claimant and who is the defendant. Because he said this is the qaida that's applied in this. If al-yaqeen la yazuru bishak, this is what the qadi is going to look at when he's hearing the two arguments. So for instance, if a man comes, if a man says he has to leave this house because he sold it to me, and the other one says, I didn't sell my house. Here we look, what is certain? What's certain is the man he owned the house. Now what's uncertain is, did he sell it or not? Now since certainty is not removed by doubt, because the doubt here is about whether the house is sold or not. So the qadi sees who's the mudda'i and who's the mudda'i alayh, the one that's the claimant and the defendant. And so what the qadi will say is, well, the origin is that he owned it, so you have to bring me proof that he did, because the al-baynatu ala al-mudda'i, the onus of proof is on the one who's the opponent, the one who's the claimant, who's saying, he owes me this. The same, and he asked the women to excuse his example, but he said a woman comes to the qadi and she says, my husband divorced me. And then the qadi looks at the husband and says, is this true? And the husband says, absolutely not, I didn't divorce her. Well, the origin is بقاء ما كان على ما كان, that something stays the way it was. So they were married, she agrees they were married, she's claiming now. There's shak in it because he says, no, we weren't. So the qadi, he's got doubt. So he looks at who's bringing the doubt. The one who's making the claim is bringing the doubt. The other person, he has yaqeen. No, I'm married to her. The other says, no, we're not married. He divorced me. So the origin was that they were married, and what's been introduced is doubt. And so that shows who the claimant is and who is the one who is defending himself. So the Shaykh said that this is also, the Malikis have an expression that they use in their legal axioms, that the people are always considered to be in a state of well-being or innocence or not harmful before they are considered to be people who are aggressing. So he says that the foundational state of human beings is adam al-ada, that they're not aggressing on people. That the aggressor, is the one who's claiming that somebody aggressed on him, he's bringing in the doubt. So when you look at human beings, you consider that they're peaceful by nature. That's how the qadi looks at them. He's not looking that they're aggressive by nature. He's looking that they're peaceful by nature. So you have to prove that they're not. And so this is another example of this. And he said also that another expression is mahmulun ala al-idhn, that people, you always assume that people have to give permission before. So if somebody says taking something or something like that, the idhn is what's always considered. First, people can't just do things that they want with other people's things. They have to have that permission. And then another principle that comes out of the hadith from this is that the had punishments, which are for felonious crimes where there's specific penal punishments. In other words, the Sharia dictates. That's called a had punishment. They're called hudud, like cutting off the hand of a thief. The al-hudud tudra'u bishubuhat, that you always try to avoid implementing had punishments or the penal code whenever there's any doubtful matters. So again, this is based on this qaida, that there has to be absolute certainty. When you put somebody to death, for instance, you can't do it based on a preponderance of evidence. Or it looks like he did it. No, you have to be absolutely certain. And so this is how this qaida relates to judges and how they go about. And also stealing. The Shaykh mentioned if somebody steals, if somebody says, look, he stole something from me, الناس محمول على العافية. You would consider that person's not a thief before you just assume that he's a thief because somebody says he's a thief. So people are not considered thieves until they're proven to be thieves. And so again, that's how it's going to apply. If people have, I'm going to take 4 questions, inshallah. 2 from the ladies' side and maybe 2 from the men's side. I mean, we should do 2 and 1. No, I'm just kidding. So the Shaykh said that the plant that the tobacco comes from, the tobacco plant, he said that asr al-ashya tahara, that this is tahir, and things that are pure are good things. So he said that is the foundation when we look at it. What then has to be proven is that the harm is not specific harm, but rather general harm. In other words, that it harms everybody. And in that case, if that is indeed proven, the thing itself is not haram, but it becomes haram because we have realized that the application of a legal principle is now warranted by what we've discovered about this thing. So the actual prohibition comes from the principle, not from the thing in and of itself. And he said that the only reason that there would be a difference of opinion is because the ulama might not have that information. In other words, if indeed they heard from doctors, and that's the area of doctors to decide that. That's not the faqih's business. He doesn't determine whether something's harmful or beneficial in food or tobacco or things like that, unless he knows it's haram from Allah. But those things, poisons and toxics, if it's something everybody knows, that's a different thing, like arsenic, something like that. But if it's things in which the harm is accrued harm, it's not something you see immediately, it's something you see over a long period of time, and that's something that is determined through statistical studies, for instance, now that are done, then that's another matter. If it becomes agreed upon amongst the doctors, in other words, the doctors might differ. Some say oat raises your cholesterol, others say it doesn't. They differ about things. So, but if they're agreeing, if all the doctors have agreed, we have enough statistical evidence to show that tobacco indeed is harmful for human beings, then that's it. It becomes haram, and there can't be any khilaf about it. But the thing is not haram in and of itself. It's important that people understand that, because only Allah can do that. Only Allah can make something specifically haram. It becomes haram because of the application of the principle, right? Tahqiq al-manat. The principle, it's realized where it applies to, and that's where the prohibition comes. So the Shaykh said that really it's another field. We're not. The question is about using sexual proof if it's built on a weak hadith, but the thing in question is beneficial. What would the ruling be? Does the rating of the hadith have any concern? And the Shaykh said that really this is another area of study, and that is how the hadith, the relationship of the hadith to derived legal rulings. And he said the ulama have differed about it. Some of them consider the weak hadith and other ones don't. He said, for instance, that Ahmad ibn Hanbal, he applies the weak hadith. He prefers it to analogical reasoning. Another example of the ulama in this question, some of them say absolutely not. You never use a weak hadith. And other ones say indeed you use it for things that are related to virtuous acts. They're not related to legal rulings of the halal and the haram, but they're rather related to those virtuous things like recitation of Yasin, something like that, virtuous acts that one draws near to Allah with. Some of the ulama said that it's permissible, and even there they have stipulations on it. And he mentioned that Sidi Abdullah ibn Hajj Ibrahim fi Tar'at al-Anwar, which is his abridged version of the famous 1,000-line poem on the technical vocabulary of the muhaddithun, mentions that the weak hadiths indeed are used with condition, and some of them say that it's not, and others say no, that you can use it without any conditions. So these are the three opinions that have come from the ulama about it. But he said that the ulama really, you have to go into, they have techniques whereby these things are determined. And you really, studying is a long process to get to the point where you really understand all the variables involved in the process of deriving legal rulings, which is why obviously ijtihad is anybody that thinks that they can do this stuff nowadays, I think, is a real deluded fool. But everybody's entitled to their opinion. سائل يسأل. He said the Shaykh also wants to add an additional remark about this, and he said weak hadiths are not one, and it's important to understand that. Some of them divide them into 40 different categories, more or less. it's important to note that not all weak hadiths have the same ruling. Some can be extremely weak. Others actually can be quite close to being good hadiths because there's a lot of different narrations of them, even though they're all weak. So he said it's not an easy black and white type situation. You can't give a one-time answer. You have to really look at every individual. And this is something that's really essential to our sacred law, is that you have to really look at each individual case. Unlike allopathic medicine, where everybody who has the same disease gets the same medicine.